Okay, we are now on the record for Wednesday morning civil docket, November 3rd, 2021. Happy Wednesday. You're almost through with the week. So let me start with quick announcements. Attorney James Sahadi.
Good morning, Your Honor. James Sahadi here on number 24 on your docket.
Okay, that's CL 210915-I, Sylvia Gutierrez et al. Versus Shell Point Mortgage Servicing et al. Yes, sir.
Yes, Judge, we're here on a show cause order. If Your Honor would recall, this case was removed to federal court, staying the proceedings. At the time that the show cause order was issued, the case was still pending in federal court. And although the case had settled, we were unable to file the non-suit here in the state court because of the pending federal court. Now the case in federal court has now been non-suited, and I went ahead and filed a notice of non-suit and an order on that non-suit in the state case, Judge.
Okay, and what date did you file the non-suit?
The non-suit was filed approximately a week ago, and then this morning I noticed on the docket that no order had been filed, so I filed that this morning. In addition, Judge, I filed a motion for release of bond. My firm had posted the bond on this case, and we're just asking that that motion be granted after the non-suit has been granted.
Okay. And do you have an order to that effect?
Yes, ma'am. That has been filed.
Okay. Then okay, as soon as the order for the non-suit hits my queue, we'll sign off on it, and I will grant the motion for release of bond and the order that's attached to that as well.
Thank you, Judge.
All right. Anything else?
Nothing further, Your Honor. May I be excused?
You certainly may.
Thank you, ma'am.
Okay, Ms. Orellana?
Good morning, Your Honor. I'm here on number 18, although it's been crossed off from your docket.
Okay, that's CL 170613-I. Okay, so then the order setting hearing for the motion for default was already filed. Okay.
Right, Your Honor. I'm just waiting for the date whenever the court receives that.
Okay.
I'll be waiting for it, but I have nothing further on this case, and the defendant is pro se and the other defendant was non-suited.
Okay, then we'll go ahead and issue that setting out to you, and then we'll see you on that date.
Thank you, Judge. I have nothing further. May I be excused?
Yes, ma'am.
Have a good day.
Thank you. Mr. Bravo.
Number 27 on the docket.
F 1738-21-9, in the interest of a minor child. Is that with Mr. Flores?
Yes, Your Honor.
Yes, Your Honor. Javier Flores, on behalf of the petitioner.
And Mr. Bravo, you're here on behalf of the respondent?
On there, it says the item, Your Honor.
Oh, as the ad item. Okay. Okay, go ahead. What's the announcement?
Your Honor, in this case, this was carried over from our previous hearing in August, in which the court had set us for a status on publication. We've had some issues going back and forth with the clerk, but we finalized that already as of the day before. And so we should have publication here soon, Judge. I don't know if we could have maybe another 30-day status or whatever the court feels comfortable with, Your Honor.
Okay. Ms. Rivera, how soon would we be able to get them in?
Judge, the soonest we have would be December the 15th.
Okay, would that give you enough time, Mr. Flores?
November, yes, Your Honor.
December, it would be December 15th.
Oh, December? Yes, Your Honor.
Okay, then December 15th at 9:30.
Thank you so much, Judge.
Okay, anything else?
Nothing further, Your Honor.
All right. Okay, you're both excused. Okay, Mr. Pettis?
Morning, Your Honor. I have number 31 on your docket.
Okay, CL 142185-I, Velia Jimenez et al. Versus Bernardino Hernandez. Yes, sir.
Yeah, I substituted in this August. I took a look at the file. It appears we cannot find the defendant to serve. So at this point, I just need 60 days to file a default judgment.
So you have, the defendant is,
We've served the defendant, but
Okay,
he's failed to file an answer or give notification to his insurance company.
okay. I would have a January setting only available for that time period. Ms. Rivera, can I get a January setting?
Yes, Judge, January the 31st.
Okay. January 31st at 9:30.
That's perfect, Your Honor. That's all I have. Maybe excused.
You certainly may, sir. Oh,
It was for a default judgment, correct?
That's correct.
yes.
It was going to be filed, Your Honor, just so I can make a note.
Yes, he's gonna file they can't find the defendant, so they'll be filing a motion for default judgment. And then on the order setting hearing, go ahead and put January the 31st at 9:30, Mr. Perez.
Perfect, Your Honor.
Okay. If nothing further, you may be excused.
Thank you.
Mr. Flores? Mr. Flores, you're on mute.
Thank you, Your Honor. I'm on this matter.
On which one?
Number 6 on your docket, Your Honor, and we just need more time. I filed a motion for continuance. I need to handle some jurisdictional issues.
CL 21-3251-I, Dora Moron versus the heirs of Andres Garza. Okay, have you perfected service?
Have I what, Your Honor?
Have you perfected service?
Service has been done via sheriff's posting.
Okay. All right, and how much time are you requesting?
A month, Your Honor.
Okay. December 15th at 9:30. That's the soonest I can get.
Okay.
Anything else?
That'll be it, Your Honor. Thank you very much. May I be excused?
You certainly may. Mr. Montalvo?
November 9th?
No, December 15th.
Thank you.
Yes, Your
Okay, hold on. I don't know, Mr. Flores was in this hearing or another hearing? Okay. Mr. Flores, was that it?
Yes, Your Honor, that's it, and I was on another hearing at the same time. I
Okay.
apologize.
All right. Okay, Mr. Montalvo, go ahead, sir.
yeah,
No, Rick Montalvo.
Okay,
I'm sorry.
Your Honor, I'm here number 35, set for a status conference this morning. Your Honor, this is a pro se defendant. This case was deposed on the March the 21st of this year. Essentially, you're asking for more time, Your Honor. It has to be mediated, and that's the only thing we're lacking. The last communication we did have with the adjuster was October 22nd to reevaluate the offer they were providing us.
Okay, so that's on CL 184486-I. Our office was notified by the clerk that Mr. Sendes was downstairs, but I don't think she's been able to get on, or I haven't seen. Let me see. Is there Luz Maria Resendes? Luz Maria Resendes? Okay, well, I don't have an issue giving you more time, Mr. Montalvo. So discovery has already been done and all you're going to do is mediate this?
Yes, Your Honor, that's the only thing lacking is mediation. Hopefully, we can resolve something at that mediation.
Okay, I'll have an order of referral sent out to you by the end of the day.
Thank you, Your Honor. That's all I have. May I be excused?
Okay, well, hold on. Let me have you come back on January the 31st at 9:30.
Thank you, Your Honor.
Okay, thank you. All right, Mr. Sabo?
Good morning, Judge. I've got number 33.
CL 196725-I, Bernardo Trevino versus Eunice Marin.
Yeah, Heather Abreu's on the other side. I don't.
Yes, I'm here. Thank
is
you.
there-
Heather
oh, there you
Abreu
go.
on behalf of the plaintiff.
Okay, and what is the
it-
announcement?
It's a status hearing, Judge.
How are we on discovery? Have y'all
We're
I
progressing.
believe everything's been completed at this point.
Depots have as well?
Yes.
Look, I've got that, yeah. Depot's taken. I don't know if we've mediated, but I mean, we'll figure out if we need to and who we can use once we get to that point, so.
Okay, so then discovery has been completed, all the necessary depositions have been taken, so the next step would be either if you all don't agree amongst yourselves, of course, you'll need to mediate it.
Right.
So
Yeah, we'll agree.
how much time do y'all think you're gonna be able to get this mediated? The holidays are around the corner. So
Yeah, I
it's okay.
think,
Be
February-
I think
feasible.
it would
February,
probably
March.
be February or March. Yeah, it's hard to get dates right now.
Okay, so then you'll probably be mediating this and maybe in February? Okay,
February, March.
Yeah.
okay,
March.
all right, Ms. Rivera, can I get a late March date then?
March the 30th, Your Honor.
Okay, March 30th at 9:30. I'm gonna leave it up to you all to agree on a mediator and when to mediate this, and then I'll see you back here and you can report on March 30th at 9:30.
Sounds good. Thank you, Your Honor.
Okay,
Thanks. That's all I've got.
I
Maybe
have- I'm sorry. Go ahead. I have a couple other matters, Your Honor.
okay, Mr. Sabo, that's all you have?
Yes, it is. Thank you. Maybe
Okay.
excuse.
Yes, sir. Okay, Mr.
Thanks.
Brew, what else do you have?
I have Luis Santilla versus Felicia Rivera. I believe it's number 36 on the docket.
Yes, CL 20-0862-I, Luis Sustaita, that's Sustaita Junior versus Felicia Rivera et al. And Mr. Denzer is also here.
Yes, Judge. Nick Denzer for the defendants.
And what is the announcement?
We have depositions in this matter in 2 weeks, so we're still in discovery phase. After that, we'll hopefully be either able to settle this matter or mediate. So we'll just ask for some more time, maybe March or April.
Okay, Mr. Denzer, anything to add?
That sounds good, Judge.
Okay. Why don't y'all come back since on March 30th at 9:30? And maybe you'll be on the same timeline as your other case.
Sounds good.
All right, thank you, Judge. May I be excused?
Yes, sir.
Thank you.
Okay, Mr. Brew, your next case?
Okay, I have number 20 on the docket. Edwin Valdez versus Dora Estrada.
CL 193318-I. And that is number 20. And what is your announcement?
We have settled this matter, Your Honor, and we are just waiting to get the lien reductions from the hospital so that we can provide the final settlement information to the defendant. So we just need a little bit more time to get those reductions in, and this matter should be all resolved.
Okay, how much time do you think you'll need?
I think realistically, maybe 30 days.
Okay, then I'm gonna set a tickler for December the 10th.
Okay,
And if it's not in by that time, then we'll set you up for a hearing.
sounds good.
Your Honor, good morning. Victor Quintana on behalf of the defense on that case. That's on December the 10th at 9:30, Your Honor.
No, I'm gonna set a tickler because you all are just pending the documents to be submitted. So since you're still getting the lien reductions, the only reason I set it for a show cause was because the timeline, the time had already passed for the previous tickler to see if you all had submitted the documents. So what the court coordinator will do is go back and look to see who has not met that tickler deadline. So I'm going to give you a new tickler deadline of December the 10th. You all don't show up, just have your paperwork in before that date.
Thank you, Judge.
Okay,
And
sounds good.
Your Honor,
Okay,
I have 2 other cases before Your Honor this morning, Judge.
okay, Mr. Quintanilla, have you all filed a notice of appearance on this case? Because I don't have you as defense counsel on it.
Oh, yes, Your Honor. I've been the defense lawyer since the case initially started, Judge.
Okay,
That
you
ref-
might want to check with the clerk's office why they don't have you on there then.
Yes, ma'am. I'll do that, but yes, I've been representing the defendant since the initial start.
Okay, let me see if Ms. Abreu has concluded her business with the court, and then I will move on to you, sir.
Thank you, ma'am.
Thank you, Your Honor. I have concluded all of my cases, if I may be excused.
Yes,
Thank you. Have a
Okay.
good day.
you too. Okay, Mr. Quintanilla, what other case do you have?
Yes, Your Honor. I have number 17, Judge.
CL 22058-I Martin Carrion, Carrion versus Juana Vasquez.
Yes, ma'am. And I represent the defendant in this case. There's a motion to compel that I filed on behalf of my client. Yesterday afternoon, I did speak to Mr. Gonzalez, plaintiff's counsel. We agreed, Judge, and by the way, I do have permission to talk on his behalf. We agreed that I was going to ask the court for 60 days. He's in the process of securing some medical records, which I need to continue evaluating the case from the veterans of the VA. And he's having a little difficulty, so I'm going to ask Your Honor to, if I may, Judge, to have another 60 days so we can get that squared away and then move on to whatever else we need to do on the case.
Okay, then that's fine, January 31st at 9:30.
Thank you, Your Honor.
Okay, anything else?
Yes, Your Honor, and I do have number 28 on the court's docket, and I believe I saw Mr. Santos somewhere there.
I'm here. Good morning, Judge.
Good morning, sir. Okay, that's CL
Good morning, Mr.
181247-I, Jesus Zuniga et al. Versus Adrian Garcia.
Yes, Judge. Judge, we're set for a status hearing on this one. I know we've been moving forward with this case with some discovery. Mr. Quintanilla has sent me some discovery, so we're going to be responding to that as well. We've, filed our affidavits, medical records, and billing, so they have that information. I anticipate, pretty soon we'll be sending them discovery as well. And then after that, hopefully we're in a position to take depositions and mediate the case.
And Your Honor, this is a car accident case that I came into the picture after the parties had mediated with Mr. Garza, Your Honor. So between us, and by the way, I represent Mr. Garcia Chavez, Your Honor. Between my client and the plaintiffs, we have not mediated the case. I may have to go back and maybe perhaps take the depot since I was not involved at the time that Mr. Santos' clients were deposed. I'm not sure yet on that point, but certainly we at least need to complete some discovery, at least on my part, so then we can move on to a mediation or possible resolution without mediation, either or, Your Honor.
Okay, so then what time frame do you think you all are looking at to get to that point?
Realistically, Your Honor, given the holidays and all that, I'm going to ballpark it at 90 days, Your Honor, with the court's permission.
Okay. I think I'll give you all some time to be, I'll be realistic with the time as well. So I'll go ahead and have you guys come back on March the 30th, and let's see how far you get on that.
And is that
a lot of time?
Is that for another status, Your Honor?
Yes. And then hopefully if you've mediated it and settled by that point, then that's great. But if not, then we can see where you're at that time.
Thank you, Judge. Appreciate it.
Yes, Judge. Thank you, Judge.
Okay.
And that's all
Judge,
I
have one other, I was going to say, I have one other matter, but go ahead, Mr. Quintanilla.
I apologize. That's all I have, Your Honor. Good to see you, Judge, and may I be excused, Your Honor.
Yes, thank you. Likewise.
Have a good day. Thank you.
Thank you. Okay, Mr. Santos, what else do you have?
Yes, Judge, I have one other matter. It's number 37 on your docket. This is Ortega, CL 172275-I.
Okay, and that's number 37 on the docket. And
Yes,
were
ma'am.
you making the announcement for both of you, or is Mr. Hernandez present?
I
Good
don't
morning,
see,
Your Honor. Michael
there you
Guerra
go.
here for the defendants.
Okay,
So Judge, on this one, we're set also for a status hearing. I know Mr. Guerra has been reaching out to me and we've been going back and forth. He's got some numbers that he's offered. We've been looking at them very carefully. I still don't have a final answer. I'm closer to one, but we're trying to move forward towards resolution. And I believe this is pretty much the final leg. We can get this case resolved, great. If not, we're in a position, I guess, to move forward, with trial. But because this case was mediated a while back, I know Mr. Guerra just, he's been on the file recently, last few months. Is that correct?
Yes.
Okay. And so with that, we've kind of renewed efforts to see if we can get this case resolved.
Okay, Mr. Guerra, do you want to add anything?
No, Your Honor. I'm confident that we're able to, get this settled once Mr. Santos runs the numbers. But we've done all depositions. We've mediated this case. If it can't get resolved, the only thing left to do in this matter is trial, Your Honor.
Okay. So then we'll set it for one more status and see where you're at. And at that time, I mean, you can let me know whether your mediation was fruitful or not. Will you be agreeing to a mediator?
Judge, I don't think we need to mediate it. We've already mediated the case one time, and we've been having pretty, easy conversations in terms of the numbers and where we're at. So I don't think there's a need for mediation at this point.
Okay, so how much time are y'all requesting in order to decide if you're accepting those numbers or not?
I'd say 30 days, Your Honor.
Yeah, that's fine, Judge.
Okay, so we'll come back on December the 15th at 9:30. At which time you can notify me whether you've accepted it and moved on, or if we do have trial dates already that we'll be giving out. You should now, I made this announcement at 2 previous hearings. If you want to file your motions for DCC, you can go ahead and start doing that. And we are setting DCCs up, and we are setting trials, just so you know, for our court. We will not be able to be in trial until late May, early June, and then we'll start. And we'll probably be in trial pretty frequently. So we're getting that geared up. But as you know, I still have a virtual courtroom, and we'll probably have one until the new courthouse is ready.
Okay.
Okay.
Sounds good.
All right. We'll
That's
see you
all I
back
have, Judge.
here. All right. Thank you.
Okay. Thank you.
Your Honor, I have one other matter this morning,
Okay.
but it is a contested hearing.
Okay. And who's on, what number is it?
It's number 7 on your docket, Your Honor.
Okay. And Mr. Reyes is already on, right?
Yes, Judge.
Okay. So then if you'll be on standby, I would check back. If you have other hearings, why don't you check back in about 30 minutes?
Thank you, Judge.
Yes, Your Honor.
Okay. All right, Ms. Barreto?
Good morning, Judge. I have number 26 on the court's docket.
Okay, CO 186386-I, Francisco Gonzalez versus Clemente Villarreal.
Yes, Judge, I am on behalf of Mr. Villarreal. I don't see Mr. Gonzalez, so I'll be making the announcement on behalf of both of us. This case, Judge, it's a property dispute. The parties resolved the dispute and there was an agreement reached. We submitted a Rule 11. I just need to work on the agreed order, Judge, so I can get that submitted within the next 30 days.
Okay, I'll put a tickler for December the 12th. And if it's not, December the 10th. If it's not submitted by the 10th, then we'll go ahead and set you up again for a show cause.
Okay, December 10th, Judge, at 9?
No, it's just my tickler. Just submit it before then.
Okay, thank you, Judge. That's
Okay.
all I have.
All right, you're welcome. Yes, ma'am.
Have a good day.
Likewise. Mr. Tamayo?
Good morning, Your Honor. I'm here on item number 29.
CL 202213-I, David White versus City of Edinburgh.
Yes, Your Honor.
Okay.
So I just had a quick announcement. Opposing counsel is Mr. Mauro Ruiz. This matter has recently been settled, and everything should be wrapped up with dismissal documents and everything by November 24th, as per our mediation agreement.
Okay, and who mediated it for you?
I believe it was Mr. Scott McLean.
Okay.
That's correct, Your Honor.
Well, oh, there you are, Mr. Ruiz.
Good morning, Your Honor.
Good morning, sir. Okay, so then I'll go ahead and set a tickler for December the 10th, and if the documents aren't submitted by then we'll set you up for a hearing, okay?
Thank you, Your Honor. Yes.
That'll be fine, Your Honor. Thank you.
Okay, anything else?
That is all on my behalf, Your Honor.
Okay,
Your Honor, if I may, I do have another matter with you. It involves the Shaheen case and Mr. Tuttle. If we could handle that, I think should be a quick matter for you.
okay. Mr. Tamayo, nothing further. You may be excused, and Mr. Ruiz, I'll go ahead and take you up. Number 25 on the court's docket, CO 173055-I. Mahdi, Mahdi, Shaheen, Shaheen versus South Texas Educational Technologies. I do believe we have Mr. Livesay here for the defense. Is that correct?
Yes, ma'am. I'm right here.
Okay, so the only reason I said it on the docket was because of the former defense counsel had not submitted the order granting the motion to withdraw. But Mr. Livesay, if you're coming in and you file your motion for substitution of counsel, I'll grant that, and I'll sign your order granting, and that'll take care of that.
Okay, that's fine, Your Honor.
And then have y'all had an opportunity to talk, or do we know how we're coming along?
Your Honor, honestly, Mr. Tuttle has not provided any file on this matter. And so despite repeated requests, so I don't even know where we're at, if there's any discovery that's been done. I know that my client has asked me to try to get this geared up to try to defend, but I honestly don't know, and I apologize to the court, but I don't know what prior counsel did.
Okay, no, and I understand. I mean, you're not going to know where you're at until you get that file. So I'll give you some time, Mr. Livesay. What I'm going to do is I'm going to set it for a status and see if you've received that file at least before the end of the year. And so I'll set you all up for December the 15th at 9:30. And that'll just be if you've had an opportunity to get that file and review it and see if you all have started talking.
Okay. All right. Thank you, Your Honor.
Okay.
Thank
And
you, Your Honor.
as soon as I receive your order granting on your motion for substitution, Mr. Livesay, I'll have it forwarded to my queue.
All right, terrific. Thank you.
Okay, anything else, gentlemen?
No, Your Honor.
Okay, thank you. Y'all have a good day. Mr. Solis?
Good morning, Your Honor.
Good morning.
Number 38 on the court's docket.
Good morning, Judge.
Good morning. All right, that is CL 181716-I, Renato Reyes versus Kimberly Renuka Suniga, that's Suniga. Okay, Mr. Solis and Ms. Trelawney.
Your Honor, we have mediated this case. We've done discovery. The only thing we need is a trial date, or there's two things. That's one thing. The second thing is, prior to you inheriting the case from the previous court, I had filed a motion for summary judgment.
Okay.
The court had heard argument, and the docket indicates that he ruled, but no order's ever been signed. So I don't know if you need to rehear arguments so we can get a hearing on that, or if you just want to grant it. I have submitted an order. It's been submitted on 2 separate occasions.
Okay, so the previous court had granted the summary judgment?
At the hearing, he said he was going to take it under advisement, and on the docket sheet, he put it was granted, but it was never signed because I think very near after that, within a week, is when it was transferred to you. But the docket sheet notes that it was granted. But if you want to have a hearing on this again, I'm fine with that too. I just want to let the court know that is the other thing that is pending.
Okay, so when it's come up in the past, what I would have to do is I would have to actually confer with the previous court and see if that was what was the intention. And I would have to let my staff know to let you know whether or not to submit the order granting, or whether it's going to be signed, or if I'm going to rehear it.
Okay.
But for now, if you all have already mediated it and you've concluded your discovery and you're ready for a trial, then just file your motion for a DCC and we'll get you set up for a DCC, and we'll give you those pre-trial and trial settings and the discovery deadlines.
Okay, Judge. What should we do about the MSJ? Would I
Well,
wait?
who was the previous court that had it?
I
Court
believe it
5,
was
Judge.
Court 5,
Okay.
yes.
Judge,
Can do.
yes.
Judge, if I may,
go
I
ahead.
can let you know, Judge, the previous court on the 8th of December of 2020, they did notate that the motion for partial summary judgment was granted and that the order was to be submitted for signature. But then Mr. Solis is correct, it was transferred the week after that.
So if you want to check with the court, I'm fine with that. My only question is, should I call your staff in a week or?
Yes. What my staff will do is they'll call both of you. Well, no, you know what we'll do is you all will call in like a simulated DCC because I do not want for anybody to say that my staff spoke to one, not the other. So
Okay.
we'll set up a time for.
At the DCC, your staff will let us know if I need to submit another order. Okay.
Correct.
That sounds good.
And then that way, if you have an order granting on file or not.
I have submitted it to this court with this courts, and then I had it submitted it when I originally filed it with the other courts style.
Okay, let me go ahead and set you for the DCC. So Ms. Rivera, can you please give me a DCC date?
Yes, Judge, the date will be November the 19th at 10 o'clock.
Okay, the other thing too, Mr. Solis, is when we do confer with the court, he may want the case back.
I'm fine
So
with
that he, so that he can conclude it since he made a ruling. But we will check and we'll have that answer for you by November the 19th.
That'll be fine, Judge. Other than that, I don't have any other concerns with this case and no other business before this court.
Okay, Mr.
Okay.
Alanis, do you want to?
I'm sorry, Judge. Nothing to add from the defense, Judge. I'm sorry, Judge. The DCC was set at what time?
At 10 a.m. on
At 10
November the 19th?
Okay, Judge. Thank you, Judge. That's all I have also.
Okay,
Have a good rest of the week, Ron.
thank you. Y'all take care.
Thank you.
Mr. McLaughlin?
Yes, Your Honor. I have two cases before the court. First one is number 22, Capital One versus Justin James.
Okay, CO 181077-I.
In this one, there was I believe a prior bench trial, but not an order submitted. I e-filed an order this morning. I have the envelope. It says that it is filed, but it doesn't say that it's been accepted yet.
Okay. Then I'll just set a tickler for December the 10th to make sure that we've already signed off on it.
Thank you, Your Honor. The second case I have is number 10 on your docket, American Express versus Alfredo Cuellar.
Okay, CO 200096-I.
And we are seeking a default judgment in this case.
Okay. Mr. Damian, please call the name out, Alfredo Cuellar, 3 times.
Yes, ma'am. Alfredo Cuellar. Alfredo Cuellar. Alfredo Cuellar.
Okay, and when are you showing that the defendant was served?
I show that he was served on January 10th of 2020.
Okay. And no answer has been on file after that date?
None that I have seen.
Okay, you may proceed.
In this case, Your Honor, we believe that the defendant had opened up a credit account with American Express. It is opened on January 14th of 2017. He made his last payment on July 1st of 2019. The account was subsequently closed and charged off with a balance of $6,625.24. We're seeking that amount in damages plus costs to the court, and would ask the court to take notice and admit the business records affidavit, the non-military declaration, and certificate of last known address, and issue judgment for the plaintiff.
Okay. And the court will admit those exhibits as evidence? And the order granting that's on file, does that reflect the relief that you have just put on the record?
Yes, Your Honor.
Okay. Then the court will grant the relief as requested and put on the record, and I'll ask for that order to be forwarded to my queue.
Thank you, Your Honor. That is all I have. May I be excused?
Yes, you certainly may.
Thank you.
Okay, thank you. Mr. Osuna?
Morning, Your Honor. Jose
Good
Osuna.
morning.
I'm on number 34, Your Honor, F-2415, 19-9, in the matter of the marriage of Lisa de Leon and Jose Monreal. Your Honor, we're set for a status. At the previous status setting, I'm the light on the case.
Yes.
I brought concerns up to the court's attention about my contention that service was defective. The court gave Ms. De Leon an opportunity to cure that. I don't see Ms. De Leon on.
I don't see her checked in either. Julissa de Leon Sanchez? Julissa de Leon Sanchez? I don't see her on either, Mr. Osuna. Have you had any contact with her?
Her husband called me seeking legal advice. I advised him that could not get legal advice.
Okay. Okay. Well, what I'll do is I'll give her, we can reset it one more time. And Mr. Osuna, have you discussed your fees with Ms. De Leon?
But Your Honor, Ms. De Leon indicated at the last setting that she couldn't afford to retain an attorney. I'll waive my compensation in light of those circumstances.
All right. Well, if she doesn't show up at our next setting, then I'll have no choice than to set it for the drop docket.
Yes, Your Honor.
Okay. So we'll go ahead and give her one opportunity, and that'll be December the 15th at 9:30.
Thank you, Your Honor. I have no further business. May I be excused, please?
You certainly may.
Thank you.
Okay. Ms. Miller, I'm sorry. I just read that you didn't have a raise your hand, but I see you found it. You're on mute, ma'am.
Yes, I'm sorry. Yes, Your Honor. Thank you. Yeah, I did. I'm sorry about that. I'm here on two cases, number 9 and number 21.
Okay, number 9, CL 181841-I, Midland Funding versus Crystal Cobos. And what is your announcement?
Yes, Your Honor. That's a motion to default that's on file.
Okay, and Mr. Damian, please call out the name 3 times of the defendant.
Crystal Cobos, Crystal Cobos, Crystal Cobos.
Okay, the name has not been, the defendant is not present. Let me go ahead and check. Okay, this was under a substituted service?
I believe so, Your Honor. I'm showing the defendant was served October 13th of 2018.
Let me see. I see an order for alternative service that was signed on September 28th, 2018. And I do not see anything to say that it was perfected.
Okay.
So there's nothing on file. If you have something that states otherwise, then that needs to be e-filed, because there's right after that order was signed, the next thing on the docket is an order of transfer.
I understood.
Okay, so I'm gonna go ahead and give you some time on that to see, and you'll come back on that on January the 31st at 9:30.
Understood.
Okay, and what was your next case?
Number 21, Huracha.
Okay, CL 187062-I, Midland Funding versus Manuel Huaracha. That's Huaracha.
Yes, Your Honor. On this one, we were asking for additional time, I guess, to prepare the motion for default. So just basically asking you to retain the case. Actually, it's not a default. The defendant was served, pardon me. But time to prepare our motion for summary judgment.
Okay, there's a motion for summary judgment that should be on file. I believe the only thing that was pending was an order resetting on the motion for summary judgment. So if that wasn't done, I was going to set it for the drop docket. But let me double check, okay? Okay. So y'all filed a motion for default back on June 21st. And then there should have been an order resetting that was filed. When you received the notice on the drop docket, you filed a motion to retain and an order. So I'll grant your motion to retain. I'll sign the order on the motion to retain, but you need to submit an order resetting hearing on the motion for default, and I'll go ahead and give you that January 31st setting
Okay.
at 9:30. So if I can get that order on the motion to retain sent to my queue, I'll sign off on it, okay?
Okay, thank you, Your Honor. That's all I have today. May I be excused?
You certainly may.
Thanks.
Okay, Mr. Khan?
Yes, good morning, Your Honor. Attorney Howard Khan here. I'm here on a motion for substituted service. The
What number are you on the court's docket?
14.
Okay, let me get to that case, please. CL 201496-I McAllen Nursing Center versus Henry Leo. Okay,
Yes, we paid the constable to serve Mr. Leo, and a deputy was assigned. He went over to the facility where Mr. Leo was residing, and the administrator of the facility told the deputy not to serve him. And I go through in fairly good detail in our motion, and the deputy seemed to say, okay, I'm not going to serve him. Now, when the pandemic first began, I can understand administrators not allowing constables into the nursing homes to serve the residents. But a year and a half later, that's no longer the case. And there are easier ways to allow service. But I don't think deputy had a right to refuse to serve the defendant, knowing he was there, because the administrator of the facility didn't want him served. And, we have this issue a lot when we have to serve somebody who may be needing a guardian. We have to serve that person for the sole purpose of making them come to the court and say, Judge, I don't need a guardian. That's the reason. This is a very important issue, getting service on a defendant. And I line out in my motion as well as, where is this good faith exception that the constable doesn't believe he has to serve a defendant because he doesn't think it's a good idea? Well, to me, that it's not his decision. It's a court's decision to decide whether somebody's incompetent or not the deputy's decision, and not the administrator of the facility's decision to decide that issue. So we're asking for substitute service to allow us to serve the administrator. Since she wants to stand there and say you can't serve him, fine, let's serve the administrator and call that service. Otherwise, I don't know what else to do on this matter.
okay. So I did read your motion, and I do see that now the deputy is also refusing to serve the defendant, and you went through in your motion to, remind me of the oath that the deputy has. And, honestly, what happens a lot of times, it's the same thing that happens in family cases. When you ask an officer to enforce a decree and then they make their own interpretation sometimes, or they're not trained in knowing how to read a certain language in a decree, or they feel that they can't enforce it, and it's really a 50-50 shot. So I understand what you're saying. Now, the only thing is that I don't know if serving the administrator would be the same thing as, because usually for a motion for substitution, it's either you're asking for publication or you're placing it on the door of the house or something like that. So I hear your arguments. I read your motion, but I am going to have to take this under advisement. And so let me go ahead and do a little bit of research on some of I know you cited the estates code and some other articles of the Constitution. So I do want to look at those, what you cited, and you have an order on file?
I do, Your Honor.
Okay, so let me go ahead and let me look at that, and I'll give myself a tickler of November the 12th. So give me about the rest of this week and next week to look that up, okay?
Yes, ma'am.
All right. So anything further, Mr. Khan?
No, just that the defendant actually has a right to get served. I know people don't think of it as a right, but under the due process clauses, defendants are entitled to be served. I mean, you just had it in your prior hearing. Where's the proof of service, counsel? I can't grant the default unless I have proof of service. That's a very important thing, and I can't. My case can't move forward without it. And posting it on the door isn't appropriate because he's in a nursing home. Publication in newspaper, that doesn't make sense to me because we know where he is. You know, that's when you can't find somebody. You appoint an attorney ad litem to accept the service for a person unknown, or you serve the Secretary of the State for a person who you can't find. But none of that is here.
No, I understand. And this lawsuit is based on him failing to pay a debt?
Yes, in his prior nursing home.
Okay. Okay. All right, Mr. Khan, thank you. And I'll take judicial notice of all the documents in the court's file. And just so you know, on your petition, you'll have to file an amended petition because we're not Cameron County, we're Hidalgo County. So.
Okay. I can certainly fix that.
Yes. Okay. All right, Mr. Khan. Then you'll hear from me by November the 12th.
Thank you, Your Honor. May I be
Okay.
excused?
Yes, you may. Thank you. Okay, Mr. Ortiz.
Good morning, Judge. Good morning, Judge. How you doing?
Good morning.
I'm here. I'm number 16, and I don't know what I have two cases. They're both the same. They're motions for substitute service. Number 16 is Gonzalo Guzman versus Nelly Peña.
Okay, that's CL 21-3108-I.
Correct.
And let me see. And your motion for substitution is based on what facts, Mr. Ortiz?
Obviously, there's nobody on their side. We have tried to serve this, the affidavit of the process server shows that we've tried to serve this woman about 4 times. And I think the rules now allow that I can serve the lawyer because I have been communicating with Eloy Garcia, who's the lawyer who's representing her, but he said to go ahead and serve her, but I can't serve this woman. And so I was asking the court to have a substitute service to allow me to serve Mr. Garcia.
Okay, so he's been retained. He told you he's been retained?
Yes, I think I've submitted that as exhibits to our motion or.
That's what I'm seeing here.
Yes,
That's your exhibit B.
correct.
Where he states that he's
Representing her.
representing her. Okay. All right. Then the order that you filed on October 12th, I'll ask for that to be submitted to my queue and the court will grant your motion for substitution.
Thank you, Your Honor. The second one is very similar. I have the order setting hearing date for today, but I couldn't find it on your list. But it's cause number CL 21-3496I.
CL 21-3496-1. Okay.
It's Encore Properties and Gustavo Guardiola versus Lucidita Castañón.
That's right.
Judge, I do see the order setting hearing. However, it didn't make our docket for whatever reason, Judge.
Okay. All right. And so, and what is the basis of?
This one, Your Honor? The process server went there. It's a gated community, and he either could not get through there or there was no answers. 3 times there was no answer on the door. However, she does have an email, and I believe now I am allowed to serve them by electronic, by social media. So I'm requesting that from the court.
Let's see, electronic messaging. You are correct, sir. Okay, and that is reflective on your order granting that was filed on October 26th.
Yes, Your Honor.
So I'll ask for that to be forwarded as well. And let me just get this. Okay. Yes, it's getting easier to have options to serve defendants under the.
Yeah, that's nice.
It's nice. Yeah, until we're the defendants. Then it's not so nice. Okay. Anything else, Mr. Ortiz?
That's it, Your Honor. I appreciate
All right.
it.
Thank you. You have a good day.
Thank you, you too.
Mr. Alanis, I apologize. Did you have another case?
Yes, Judge, I actually have a case, number 32 on the docket, and it is CL 210074. That's with Ms. Padilla. I thought I saw her online somewhere.
Yes, Your Honor. Selena Padilla here for plaintiffs.
It's a status conference, Judge.
All right. And what are you all going to report?
Well, Judge, and I'm covering this hearing for Ruben Ramirez. The notes I have here, Judge, is that we had some depositions scheduled. Unfortunately, we have had to reschedule them. So at this point, that's what we're trying to complete, the depositions of the parties.
Okay, so then the depositions that were to be held in September are the ones that are rescheduled at this point.
That's the notes that I have, Judge, that the depositions were not completed and they're needing to be, or they have been rescheduled.
Okay, and do we have new dates yet, or what are you looking at?
Judge, I do not have those notes in front of me as to whether they've actually been noticed for a certain date. I'm not sure Ms. Padilla has that information.
Your Honor, the last time we scheduled depositions was about a week ago. I don't believe we have a firm date for when the depositions will be taking place.
But in your conversations with Mr. Ramirez, Ms. Padilla, have you all discussed a time frame, 30 days, 60 days after the holidays?
Your Honor, I do not believe so. I would hope that we would be able to do it before the holidays, but I don't want to, state on the record any assumptions about Mr. Ramirez's schedule.
Well, I'm going to guess no, because Mr. Ramirez's schedule looks like it's just gotten a lot more complicated in the next few months. So go ahead, Mr.
Judge, yes, Judge, I'm sorry, Judge. Yes, his schedule probably has gotten busier for sure. I wanted to interject here, Judge, that I have a note here that the plaintiff was recovering from a surgery. So I'm not sure if Ms. Padilla has information on the plaintiff's recovery. So that might affect, even though these depositions are through Zoom, Judge, that might affect still the renoticing of the depot, the date.
Okay. Well, I need to schedule y'all for a status. So I just need a realistic date. And I mean, I don't know if Mr. Ramirez is going to be having anybody cover for him for the next few months, or it's very difficult to run your practice and run for office. Trust me, I know. So sometimes it's necessary to take some time off, or if he's going to have some help. I mean, look, I always ask for realistic, and I don't care. I mean, not that I don't care, but I would rather somebody tell me, like, you know what, Judge, realistically, we're not going to get this done in the next 90 to 120 days. And that way I'm not worried about making sure that I, get you all back in here. So if it looks like you all are going to get these depositions done within the next 60 days, I can bring you back in January. If it looks like it's not going to be done until later, then, but Ms. Padilla also has a case to prosecute here. So it's really going to be on how flexible you're going to be, Ms. Padilla, as well. So let me know. When do you all want to come back to give me a good status, not the same status?
Your Honor, I think that if the court would allow us to come back towards late January, February, then we would definitely have a productive status to report.
Okay, so we'll come back on January the 31st at 9:30. And let's see if you're able to get some progress going.
All right, Judge. Yes, January 31st, right, Judge, at 9:30?
Yes.
Okay, Judge. Okay, Judge, yes. And we'll be moving the case one way or the other, Judge.
Okay. All right. Anything else, Mr. Alanis, on any other case?
No, Judge, that's all I have for this morning. May I be excused, Judge?
Yes.
Thank you, Judge.
Thank you. Okay, Ms. Padilla, do you have another case?
Not at this time, Your Honor. May I also be excused?
Yes, ma'am. Have a good day.
Thank you, you too.
Thank you. Ms. Garza?
Good morning, Judge. I have number 23 on your docket.
F 2847-20-9, in the matter of the marriage of Ivan de la Mora and Judith Rodriguez.
And yes, Your Honor, Robert Mendoza present for the hearing. My client's online too.
Okay, I do see both the petitioner and the respondent as well as the attorneys online. And I just needed a status as to where we are on the divorce decree.
Judge, we had mediation back in August, August 9th. We had a hearing to prove up the divorce on August the 25th, is what I have. You ordered that the house be sold, and Ms. Cantu was supposed to sign a contract to sell that house by, if I'm not wrong, it was supposed to be September 1st. She's yet to sign that contract. She picked the realtor. We agreed with whatever realtor she wanted. My understanding is, speaking to Ms. Mendoza, he had already gone through the contract with his client and told her to sign it. She's still yet not signed it, Judge. She's in violation of a court order. I sent Mr. Mendoza the final decree of divorce back on September the 8th. He hasn't returned it with changes or corrections, but in his favor, I will say he did send me emails, and he did send me a positive COVID test that he was sick. He was out for a long time. He has underlying conditions. So of course, he was out for a long time. He just started coming back to work because we've been in contact through emails, Judge. But his client refuses to sign the contract to sell that house. Hence, the problem is they have another house in Corpus. My client already picked a realtor, did the contract, but there's no need to send her the contract that she's not going to sign that one either, Judge. We need for her to sign the contract on the Mercedes house now.
May I respond?
Yes.
Your Honor, first of all, in keeping with the court's announcement of Happy Wednesday, I'd like to make the following announcement. Thank you for giving me credit for my illness. It is true, I had a difficult time recovering from COVID. I'm still having some after effects, but it's cut me, I'm behind. With regard to the decree, Ms. Garza did send it to me. I have reviewed it. I have no objections. Maybe just a few inserts that I got to put in there as personal data, and that's it, and that can be signed. And of course, the delay in that is also having me been out sick. Third, with regard to the contract, I did inform my client to sign it. My understanding from her is that she and Mr. De La Mora started talking about her buying his interest out for the $52,500 or $250 because she could get a loan for that, and it was from a third-party investor. And my understanding was that Mr. De La Mora's response was that he didn't want the 52, he wanted 65. The court ordered the top price on that to be 105,000. And so that was beyond that matter. The negotiations went behind. I don't think Ms. Garza knew about it or I knew about it. I just found out about it yesterday. They were going on. And at that point, I believe my client didn't sign because she spoke with the realtor And the realtor suggested that it would be real simple if she just pays him the 52, and they don't have to go through the listing and everything, and he just signs the title over. But
Okay,
yes,
so
that's
all those things that you're suggesting, even if it was happening, would be a great scenario for two parties that have been able to work with one another from the beginning. And that's not the case here. So we're going to go with what the court has ordered and what you all have mediated. So first thing is first, that final decree of divorce needs to be executed by the attorneys and the parties. And if it's not, and she refuses to, then Ms. Garza can, submit a motion for entry of that judgment, and I will sign it. Because these people need to be divorced, and she needs to be able to enforce an order. And for that to happen, that order needs to be signed.
Right.
Now, second of all, if any party does anything that is against that order, if their actions do not line up with that order, do not reflect what I've ordered, I will hold them in contempt. Okay? I will enforce the order and I'll hold them in contempt. So it's very simple because it needs to get done. And these people do not need to be married longer than, I pronounced them divorced in August.
Correct.
And you know what the thing is, and the case law that's out there, if something would have happened to one of them or anything, they're still married. The other person would still have a right over them. And that wasn't their intention at all in a divorce proceeding because they're divorced. They were divorced, and they're not even legally divorced at this point because I don't have a divorce decree. So what that does is it ties them together for an extra whatever amount of days when nobody wanted to be, I don't see how they would have wanted to be together. Anyway, they already proved up their divorce. So Ms. Castaneda, I'm going to ask you to please let Ms. Ruiz know that her attorney has the divorce decree and she needs to sign that divorce decree because it's in line with what has been mediated and what has been testified to. And if she fails to sign it, that divorce decree will still be submitted to me and I will sign it. I know that's a lot, but if you can translate the summary of that, that would be great.
Ms. Ruiz, su abogado tiene el decreto para que lo firme y eso es lo que el decreto contiene lo que estuvieron en la última corte, lo que fueron a mediación. So, si no lo firma, lo van a meter a la corte y como quiera la juez lo va a firmar.
And that she needs to act in accordance with that divorce decree.
Y usted tiene que actuar de acuerdo con lo que está en el decreto.
Let her know that that includes signing the contract that was ordered for her to sign.
Y eso también incluye firmando el contrato que iba a firmar.
No side deals. No side deals between them two. They have to follow the decree.
No va a haber tratos secundarios. Tiene que firmar lo que está en el decreto.
Okay. So, Mr. Mendoza, if you don't have any changes or anything, and you as an officer of the court can say that that decree is in line with the mediated settlement agreement and what was testified to on the record, then please sign it. And if your client doesn't want to sign it, obviously you can't force her to sign it. But as an officer of the court, we have a duty as well that if it's in line with what, and it mirrors the mediated settlement agreement and what's testified to, just sign it. And then you all save the court's time in filing a motion for entry of judgment. But if you don't want to, for whatever reason, then, Ms. Garza can still file her motion for entry and I'm going to sign it. And, okay. And then if she still doesn't sign the contract or what have you, then let us know and then just come back. And now you're going to have a signed decree that you can attach as an exhibit to enforce. Okay, Ms. Garza?
Yes, Judge, because she hasn't been letting him see the child, hasn't turned over the items. she's
Oh,
supposed
no,
to,
no, that's not
all
gonna
kinds of
happen.
stuff, all kinds.
Okay.
Does
If
no,
that is,
no contact with him.
okay, if that, I'm not, I know Mr. Mendoza, you're gonna have a comeback, but let's just do this. This is all I'm gonna say to both of them. You do not hold the child against each other. You just don't do that. You don't use the child for games. If there is a specific outline of how Mr. De La Mora is supposed to be visiting the child, as long as he provides a schedule, if I recall correctly, and he calls within a certain time period, then she's to release the child. If not, she's going to end up facing criminal charges. I don't think that he's going to let that pass by. Now it's vice versa. When it's time to give up the child and return to her, you give up the child and return to her, because if not, then you're going to face criminal charges as well. I mean, it's not a game, and it's very easy. And for me to still remember the terms of an agreement that happened 60 days ago, one, tells you that I paid very close attention in that hearing, and two, means that there was frequent visits to this court regarding those issues. And I may not have a very good memory about a lot of stuff, but I have a very good memory when it comes to cases that come before me. So I'm not going to deal with that, okay? So I'm going to give you all an opportunity. Mr. Mendoza, get it signed and over if you can. If you don't want to, I'm not going to force you to sign it. I'm going to, and then Ms. Garza will take the remedy that she needs, and then I'll hear it like I've heard you before, and I will enforce it. Whatever is on that, we're not going to stray. Whatever's in that, time and effort was put into a mediation. And I can't stand it when after you all have mediated for 4 hours, 5 hours, 6 hours, then afterwards, everyone has buyer's remorse and, oh, let's do this instead. And then that doesn't work out. And then what? You're here. We're not going to do that. You follow what the mediated settlement agreement says, and you follow what the divorce decree says, and that's it. You want to do anything outside of that, then file a modification. That's how it's taken care of.
Your Honor, may I have something? It's Thursday today.
No, today's Wednesday. Today's Wednesday.
Oh, yeah. Okay, then we should be able to file it by Friday. It's brain fog, Your Honor.
I understand.
Judge, also, we'd like to, we have the contract on the house in Corpus. We hadn't sent it over. My client sent it to me back some time ago because if she wasn't signing the contract here in Mercedes, we didn't believe she'd sign. We'd like to send it to them within the next few days and for her to have a certain amount of time to sign it. So he can sell the house in Corpus also.
That's fine with me, Your Honor.
And just explain to Miss, I know Ms. Ruiz did indicate the last time that she was here that she understands English and she's more comfortable in speaking Spanish. Correct. So I know that she's understanding what I'm saying, but you can certainly relay the message to her. Okay. Yes, all right. So what we're going to do is I'm going to set a tickler. I'm going to give you all till November the 19th to submit that divorce decree. If it's not, then I'm sure we're not only going to be back here on why it's not signed. I'm sure Ms. Garza will be filing her own motions as well. Okay, so I'm going to set the tickler for November the 19th, and I expect that it's going to be submitted.
Thank you, Your Honor. That concludes my business with the court. May I be excused?
Yes, sir, and I hope you continue to get better.
Thank you.
Thank you, Judge. Have a good day.
Thank you. You and your clients may be excused.
Thank you.
Okay, Mr. Cavazos.
Good morning, Judge. Jaime Cavazos here, number 19 on your docket, Judge.
F 4922-19-9, in the interest of minor children.
Judge, we're here for a show cause hearing. We were able to get to an agreement with the OAG on Friday, actually, and the parties signed the agreement, the agreed order. I filed it early this morning. The OAG, after further review, decided that they are going to go ahead and honor the DNA results that were ordered by the previous court.
Okay, so then since you submitted the order today, as soon as it's accepted, I'll ask for my staff forward it to my queue.
Thank you, Judge. And it was signed, I don't know the OEGs on the call, Judge, but it was signed by the OEG and both parties.
Okay. So Mr. Cavazos, and then what are you going to do? Like, what's the next step one, because they honored
Judge,
it? What do you want to
Judge,
do?
when I spoke with him, initially he had indicated he was going to order DNA on the younger child. He's telling me we don't need DNA as long as we dad is willing to come and say he's the dad. That's our next step. But I wasn't sure, Judge, if it would non-suit the young child and then file a news for her so as not to have both children.
Right. Well, the biological father of the younger child needs to file their paternity of acknowledgement. And have they done that? Has he done that yet?
No, Judge.
Okay, and then I'm gonna make a finding to accept it. Well, I'm not saying I'm going to make the finding, but I'm supposed to make the finding, right? And then once that happens, then that child will be removed from that suit, so that we're only dealing with the child that is pertaining to him.
Judge, and I apologize. The older child is the one that has his name is the one that we're asking. So actually the younger child is the one we're going to find that is his.
Okay.
And the older child,
right,
Lorraine.
Okay, and then so Lorraine, the older child, and I try to refrain from saying their names on camera.
Okay, Judge.
And so the older child, that's fine, but still that biological father who's coming forward and saying they're the dad needs to have something on file. But the AG's office can provide you some guidance with that.
Judge, if I may, there is no father coming forward. It's basically, we're finding that my client is not the father. I don't know if Ms. Varela has indicated, not that I know of.
Okay, so then the DNA test, because then I misunderstood what you just stated a little bit ago then. So the DNA test that occurred on which child? The younger or the older?
On both of the children.
Okay, and then that DNA test indicated older child was not his and younger child was his, correct?
Yes, Judge.
Okay, so now the AG's office is going to accept that DNA result, right?
Yes.
Okay, so then now speak to the AG's office to see, because he's ordered to pay child support right now on the older child too?
No, there's no current orders, Judge. But the issue was that the child that had, like I said, the child that had his name is not his child. So this is the one we're doing today. And then the younger child, we're going to go ahead and file so that he can be adjudicated as the dad.
Oh, okay.
On the younger child. On that younger child, the OAG has told me, now is that they will not require DNA for that finding.
Okay.
We have DNA,
you have it
but
anyway.
They won't require.
Yeah, you have it anyway. Okay. So then I'm just gonna set you for a status. I'm gonna let you get it figured out over the next 60 days. Just come back on January the 31st. That'll be plenty of time for you to see.
Thank you, Judge.
And that way you can decide how you want to move along with it. Okay. And you can come in sooner if I can accommodate you, if you have a motion or something.
Yeah, Judge, the court has always been accommodating. So if I have something earlier, I'll send it in.
Okay, thank you.
Excuse me, Judge.
Yes.
I'm so sorry. I have a question. I wanted to see if I could get an attorney appointed to me by the court, if that was possible.
Unfortunately, we only do criminal appointments for criminal cases, for indigent cases. The only time that you would be entitled to a attorney being appointed to you is if there was an enforcement action where they were having jail time as a consequence, because then that is a criminal action. And that's not the case here. So I cannot appoint an attorney to help you on a family law case. Now you can contact legal aid, or you can also, sometimes we have clinics. The county will have clinics to where they ask for volunteers of attorneys to do pro bono hours. but I don't know of any that are coming up soon.
I did use legal aid and they just helped me with my last case, which was against Mr. Diaz for a protection order. So I believe they told me they can only take a case a year or something like that. I have applied for the Purple Door. They gave me all kinds of assistance, like as well for victims that have been abused and everything. I haven't really gotten heard back about an attorney, but the legal aid, I have heard about it. But I was just trying to see if there was one that could be appointed to me if that was my option. But and as of this hearing, so what that I'm understanding, we're knowing that Lorraine, of course, Lorraine is not his, and Bella, the oldest child is not his, and the youngest is his. Now, so from here, where do we go? Where's my stand in this?
Well, that's what I'm giving Mr. Cavazos an opportunity to figure out, because since he's the one that initiated the litigation or the process, then it's his case. He can prosecute it how he wants to. So I can't tell him what to do. So he's gonna have some time before he decides what it is gonna be the best way to proceed on this case. So I'm giving you all pretty much 90 days to see how you all can move forward with this. Your next setting will be on January the 31st at 9:30.
Okay. Sounds good.
Judge, if I
Thank you,
may?
Judge.
Sure.
Yeah, Judge, last time we were here, I mentioned that Ms. Villarreal has not provided the court information to contact her. I've been providing her the Zoom information and all that. I did call the court yesterday, and I believe they have a Houston address. And I know she doesn't want to share it with us, and that's fine, but I just would ask Ms. Villarreal again to provide some type of information so they can contact her directly.
So Ms. Villarreal, if you have an email address,
I do. May I correct that? I don't understand where they're getting a Houston address or anything. I have updated everything to my address. I get all my mail, everything. I've been getting the district attorney's letters, but for some reason, these past months since the last court, I have not gotten anything. Like if something changed, and my email's the same, my number's the same, my address is the same. Nothing has changed. So I don't understand why they're bringing up a Houston address. I have not been there in almost a year. Yeah, more than a year, 2 years.
Okay, so because right now you're representing yourself, you have the obligation to keep technically your opposing counsel, which is Mr. Cavazos, updated with your contact information, which means that you have to provide him the email address and a physical address if he needs to deliver have any packages sent to you, discovery mailed to you, things of that nature, paperwork that may need to be mailed to you. Okay.
And
now,
that all of that is going to be private, correct? Because his client, I have a protection order against his client.
Okay, and if the protection order has a non-disclosure statement, then he cannot give that information to his attorney. But if it doesn't have a non-disclosure statement, that's another issue.
Yes, but everything is confidential.
Okay, has Mr. Cavazos been given a copy of that protective order?
He's the one that handled the case.
Okay,
Judge, if I may?
Sure.
Judge, I have her email address. I just don't want to give it to the court without her permission. All I'm asking is her provide the email address that you gave me that I haven't shared with anybody, not even with the court, so that they can contact you, because I know this morning you were texting me early looking for Zoom information, and I just want to make sure you get it so that if I'm busy and I'm not providing that, I guess it's not my job.
And it's not Mr. Cavazos' obligation to provide you with the Zoom information. It's your obligation to keep the court updated with your information. So I'll need for you to later on in the day after 3 o'clock to try our office and give us your updated email address. Do not put it on the record right now because you're on YouTube.
Oh, no.
Okay.
No, I'm not.
So,
but I did. I have been contacting the general attorneys.
Stop. First of all, it was for quick announcements. This has gone way over quick announcements. Okay. You have other attorneys that have other cases that are going on that they probably have way quicker announcements. Look, I'm not here to give you legal advice. You chose to represent yourself because of whatever situation you're in. I'm only obligated to treat you as an attorney. but you're held to the same standard. So Mr. Cavazos doesn't have to give you the Zoom link. It is your responsibility to keep the court updated. So I'm telling you, call after 3 o'clock today. Make sure my staff has an updated address for you and an updated email address for you. But I will tell you, your email address will be attached to an email that goes out to all the attorneys that will be having a hearing on the whatever day that you have, because that's the only way you're going to get the Zoom link, and that's the only way that you're going to get the docket. So if your email is not included in that protection order as being protected, I don't have any obligation to keep your email private from anybody else. So you're going to call this afternoon. If you don't want to use your email address, then you provide us an email address where you can receive the link and you can receive the docket. And then you're going to be responsible on that email address. Whatever email address you give to us, you're going to be responsible in receiving information at that email address. If you don't receive it, it's not Mr. Cavazos' job to give you that information. Do you understand that?
Mm-hmm. Yes, ma'am.
Okay, that's it. So you'll come back on January the 31st at 9:30, and I'll see you then. If you want to hire counsel between now and then, that's plenty of time to hire counsel in order for them to get up to date on this case. Okay?
Okay, thank you.
All right.
Thank you, Judge. May I be excused?
Yes, you may.
Thank you, Judge. You have a good Wednesday.
Thank you. Likewise. Okay, Ms.
Thank you.
Palacios Love.
Hello. Good morning, Your Honor. I have number 2 on the court docket.
All right, F 2637-21-9 in the matter of the marriage of Jose Cerda and Mireida, Mireyda Cerda. All right, and Ms. Arispe is also here.
That is correct, Judge. Judge, this is an agreed divorce, if I'm not mistaken, Judge, and my client is Spanish speaker. I don't know if the court wants to take us now to prove up the divorce.
Okay. And both parties are here, correct?
Yes.
Okay. All right, if you can just okay, they're both Spanish speakers? Okay. If you can just indulge me and just give me a moment and let me see if the other 4 attorneys that are left have some quick announcements.
Yes, ma'am.
Okay, Mr. Alvarez?
Yes, Your Honor.
Okay, which case?
I'm on a family case, Judge.
Okay, is that on Villarreal versus Flores?
That is correct, Your Honor.
All right, F 1314-20-9, Carrie Villarreal versus Mario Flores, and I do have Mr. Palacios also on as well.
I represent Mr. Flores.
Sonny Palacios, Ms. Villarreal.
Okay, and we're here on whose motion to withdraw?
Judge, that would be my motion to withdraw. Judge, on this case, we did proceed through mediation. Earlier, we did hear the court admonish some previous people in open court regarding mediation, settlement agreements, and buyer's remorse and outside influence. And that's the case on this one, Judge. We did go through mediation. There was an MSA. There was an agreement. However, we did file the motion because due to outside influences, the MSA was not going to be signed, and which is fine. She could not sign it if she doesn't want to. However, that does affect my ability to represent her effectively. Since that day, since October 6th, we have sent 3 emails which have not been responded to. So we're asking that the court allow us to withdraw and allow Ms. Villarreal the opportunity to hire a counsel of her choosing.
Okay, Ms. Villarreal, how much time are you requesting to hire counsel?
Good morning, Your Honor. I do already have another counsel. He's just waiting for basically this docket to be released so that he can come on.
Okay, so the court will grant Movin's motion to withdraw as counsel. And do you have an order granting already on file?
There is an order granting on file, Judge, and as an officer of the court, as soon as a new counsel contacts our office, we'll gladly send over all the documents.
Okay, so then I'll go ahead and ask for that order to be forwarded to my queue, and I'll sign off on it. Okay.
Thank you, Judge.
Yes, Your Honor. And just to inform the court, yes, just to inform the court, I represent Mr. Flores that my client did sign off on the mediated settlement agreement. We're just lacking that one signature. But if Ms. Villarreal can just forward, or whoever the lawyers can be, forward their contact information so I can continue negotiating with them. I'm sure we can work this case out, Judge.
Okay, then I'm gonna order you back here for a status hearing on December the 15th at 9:30. I want to know by the end of the year where we're gonna go
Yes,
with
Your
this case. Okay?
Yes, Your Honor.
Thank
All
you,
right.
Your Honor.
Thank
Thank
you.
you.
You all are excused.
Thank you, Judge.
All right. Mr. Salinas?
Good morning, Your Honor.
Good morning, sir.
Judge, I'm here. This is a civil matter. It's number 30 on your docket, Fabian Ibarra versus HEB LP. I'm Derek Salinas for the plaintiff in this matter, Judge.
CL 21-2380-I, and did defense counsel present?
I don't see him logged on, Victor. I don't see Victor logged on, Your Honor. I've been waiting here since 9:30 though, and this is our first status, Judge. We still are undergoing some discovery. Depositions have yet to be taken. That would be our announcement to the court. We have exchanged written discovery, Your Honor. So we're just pending depots and obviously mediation and the like.
Have you all discussed a time frame as to when depositions will occur?
We have not, Judge. I was looking for that. I don't see any notes on that. We just exchanged discovery. So realistically, Your Honor, I would think that we could get depositions done pending Victor's schedule probably within the next 2 months, Your Honor.
Okay.
I respectfully ask maybe for another status realistically, maybe at the end of January or early February.
Okay, January 31st at 9:30.
Thank you, Judge.
If you can let your opposing counsel know, please.
I'll do it, Your Honor. And that's all I have before the court, Your Honor. May I be excused?
You certainly may. Thank
Thank
you.
you, Judge. Have a nice day.
Likewise. Okay, Mr. Medina?
Good morning, Judge. I'm here on 39 on your docket. That's F-6290-18-9. This is just to prove up a divorce. There has been an agreement reached at mediation. I don't know if the court wants to take this up or right now or have us wait a few minutes.
No, I can take it up because it's not going to take the time of translation. So we're going to be proving it up with your client only?
Yes, Judge, I don't see opposing counsel or opposing party on, but we have filed the proposed final divorce decree signed by both parties and both attorneys.
Okay, then let me call F6290-18-9 in the matter of the marriage of David de los Rios versus Angelica Gonzalez and in the interest of a minor child. Mr. de los Rios, can I please have you raise your right hand, sir? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, just have him get a little bit closer to the microphone, Mr. Medina. Okay. Now, Mr. Medina, if you'd like, since this is a mediated settlement agreement, of course, you can preface the testimony by asking the required foundation questions as to whether he met the requirements to file the divorce, and then just state the agreement on the record, and then we'll just ask Mr. de los Rios if that's his understanding of the agreement, okay?
You want me to go through the mediated settlement agreement, Judge? Or, I mean, the parties have already signed off on the proposed decree.
Yes, because since there's a minor child, I either have to have an affidavit of statement of evidence or have them put the agreement on the record.
Very well, Judge. You know what, can you recall this? I need to get that mediated settlement agreement before me.
Okay, that's not a problem.
Thank you.
All right. Okay, Mr. Maldonado, do you have a contested matter?
No, Judge, I have a hearing on a motion to substitute service.
And what number is that?
I'm sorry, Judge, I don't have the case, I don't have the docket number, but
Number 12,
it's
Your
case
Honor.
number.
Okay. F3670-21-9 in the matter of the marriage of Rolando Gonzalez and Esmeralda Gonzalez. Okay, and so you filed a motion for substitute service?
Yes, on behalf of Rolando Gonzalez, Your Honor.
Okay, and what is the basis of your motion?
Your Honor, I'm looking at the affidavit of Mr. Marty Gonzalez and the return
officer citation indicating he's attempted to serve the respondent 3 times. I spoke with Mr. Gonzalez, Marty Gonzalez, to get an understanding exactly what was happening. And apparently he's trying to serve the respondent where she works. And that's the address that he put in the affidavit for attempted personal services, which is La Jolla Transportation number 2 and Western Road and 107. Apparently the respondent is a bus driver, Your Honor, and he has attempted to go serve her. He tells me I've actually talked to her 3 times over the phone, asked her to meet me at a certain location. And she says she will, but she will not. She does not show up. Mr. Gonzalez tells me also, Judge, that he spoke with the director of transportation there, and his name is Raul Gonzalez. And that he has said that if the paperwork is given to him, that he'll make sure that she gets it. Apparently, I guess he's the boss there or the supervisor.
That's not going to constitute it. The only way that it would constitute good service is if it's at her home and left with somebody there at her home, not her work.
Well, we don't have an address for her, Judge. We just know that she works there. And apparently the process server has tried to serve her there early in the morning when she arrives, but that has not been successful because, and Mr. Gonzalez, Raul Gonzalez has said, listen, please don't serve her in the morning. She may get upset. She's a bus driver. Something can happen. And the process server understands that. Says, I'll meet her after work. I'll meet her at anywhere, the store. And he's talked to her, but she just won't show up. Or says, let's do this later. So that's where we're at. We're stuck.
And I don't see it on the affidavit, but the supervisor told Mr. Gonzalez, Marty Gonzalez, that he would give her the paperwork.
Yes, he says, he's told me, please don't try to serve her in the morning because she's a bus driver and, she may be upset. Something might happen. And Mr. Marty Gonzalez says, yeah, I understand that. I'll wait afterwards or any other time. And that's why he says, I've even talked to her at least 3 times to meet me. And she says she will, but she just didn't show up at Stripes or another location. The respondent won't show up.
Okay, well, I mean, I understand it. I'll grant it, but whenever she gets served, I'm sure you might need to be prepared for her attorney to say it might be defective service, but I'll grant it just.
That'd be great if we could just get another lawyer involved.
Yeah, okay, I'll go ahead and ask for your order granting to be, I don't see one on file. I only see your motion for substitute service on file. So you need to just get your order granting on file and I'll have it forwarded to my queue oh no, it was filed on October the 26th. It's very tricky as to how they title these things.
If I could submit another order indicating that Mr. Raul Gonzalez, who is the supervisor, director, whatever, will receive the document and forward it to the respondent.
That's probably best. Okay, so then when that order comes up, we'll go ahead and have it forwarded to me, okay?
Okay, thank you, Judge. That's all we have.
All right, thank you. Mr. Molina, are you here on a contested matter?
That's correct, Your Honor. We're here on myself and John Millen are here on number 8 on your civil docket, Your Honor.
Oh, okay.
Good morning, Your Honor. John Millen representing Bracewood Property Management, the defendants. We're here on a motion for summary, no evidence motion for summary judgment, Your Honor.
Okay, then let me go ahead and you all and Mr. Reyes and Mr. Guerra are also here on the same. So I'll go ahead and just call you shortly. Let me finish with this 2 divorces, okay?
Thank you, Your Honor.
Stand by. All right. Is Mr. Medina ready?
Yes, Judge, I have it before me now.
Okay, then your client has already been sworn in. I'll recall F 6290-18-9 and you may proceed.
Thank you, Judge. Would you please state your full name?
David de los Rios.
Are you presently married to Angelica Gonzalez?
Yes.
Have you been a domiciliary of Texas for the preceding 6-month period and a resident of this county for the preceding 90-day period?
Yes.
Were you married to Angelica Gonzalez on May 25th, 2003 and ceased to live together as husband and wife on or about September 1st, 2018?
Yes.
Has your marriage to Angelica Gonzalez become insupportable because of a discord or conflict of personalities that destroys the legitimate ends of this marriage?
Yes.
Is there any reasonable expectation of reconciliation?
No.
Were there any children born during this marriage?
Yes.
What is the child's name?
Marco Antonio de los Rios.
And Mr. Marco Antonio de los Rios is now 18 years old, correct?
Yes.
But he is still in high school?
Yes.
As part of the agreement that you reached with your wife, Ms. Angelica Gonzalez, you reached an agreement at mediation, correct?
Yes.
And both parties and both attorneys signed the mediated settlement agreement, correct?
Yes.
As part of the agreement was the agreement concerning the custody and child support for your child, correct?
Yes.
And you agreed that you would be joint managing conservators, correct?
Yes.
And you were designated as primary, correct?
Yes.
And there's also an agreement that the child is now 18 years old and may or may not cooperate with this agreement as he is now an adult, correct?
Yes.
And that is designated in page 4 of the mediated settlement agreement, correct?
Yes.
And both parties did sign this agreement?
Yes.
All right, as part of the child support, you have agreed that the respondent, Ms. Angelica Gonzalez, will pay $100 commencing October 1st, 2021 until the child graduates from high school in May of 2022, correct?
Yes.
And retroactive child support will be paid by the respondent in the amount of $100 for any and all past due child support, correct?
Yes.
Is that your agreement?
Yes.
Health insurance will be provided by the respondent, Angelica Gonzalez,
Yes.
correct? And any medical needs not covered by insurance will be split 50-50, correct?
Yes.
The agreement calls for standard visitations with the agreement that, again, the child is 18 years old and may or may not cooperate with the agreement, correct?
Yes.
And you've also come to an agreement on the division of your property and debts, correct?
Yes.
And that is noted on the mediated settlement agreement as well as the proposed divorce decree that you have signed, correct?
Yes.
Do you think that the agreement is fair and equitable to both you and your wife?
Yes.
Page 38 has signatures of both attorneys and both parties. Do you see page 38?
Yes.
Did you sign that?
Yes.
All right. And you're asking this court to approve the mediated settlement agreement as well as the proposed divorce decree, correct?
Yes.
I have nothing further, Judge. I'm not sure if I left anything out that the court may want to put on the record.
No, the court, Mr. De Los Rios, so you understand that this will be final, and so you agree that this is an equitable distribution?
Yes, Judge.
Okay, all right, then the court will accept the testimony as put on the record and will grant the relief requested, and will sign the order that was filed on October 29th, 2021, and I'll ask for that to be forwarded to my queue. And I do pronounce you divorced. And as soon as that hits my queue, I will sign it, and and then it'll get sent to the attorneys, okay?
Thank you, Judge.
Okay. Best of luck to you, sir, and to Ms. Gonzalez and to your son. He has a very bright future ahead of him.
Thank you, Judge.
Okay.
Thank
Y'all
you, Judge.
take care. Thank you, Mr. Medina.
Thank you for your patience, Judge.
Of course. Okay, Ms. Palacios Love and Ms. Arispe. Let's go ahead and let's recall your case, and both of your clients are on. So that's F 2637-21-9. So Ms. Castañeda, both will need the services of an interpreter. So please ask them to raise their right hand.
Mr. Cerda y Ms. Cerda, por favor, levantan su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Juran que el testimonio que están a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Mr. Cerda? Okay, ask them to unmute themselves.
Por favor, prenden el micrófono.
Sí.
Yes.
And let them know they can lower their hands.
Ya pueden bajar su mano.
Okay, Mr. Cerda's having trouble unmuting himself. Let him know that there's a microphone button at the bottom that he should be able to push.
Mr. Cerda, abajo tiene un micrófono, lo puede oprimir el micrófono.
There we go.
¿Sí me oye?
Can you hear me?
Yes, okay, tell him to leave it like that.
Déjalo así, por favor.
Sí.
Okay, who's going to be proving it up?
Your Honor, I can just read it onto the record and then just ask them if they both agree, so we don't have to repeat everything.
Okay, so just go slow and she'll translate the agreement on the record, and at the end, we'll just ask them, like you said. Okay.
The parties stipulate that they were married on or about August 27th of 1993 and separated on or about 2016.
Okay, la pareja se casó como en el 1993 y se separaron como en marzo del 2018.
No, I'm sorry, on or about 2016.
Okay, se casaron como en el 2016, I'm sorry.
They separated on or about 2016.
Se separaron como en el 2016.
The parties agree that mom will be primary managing conservator with rights to determine residence of the children.
La pareja está de acuerdo que la mamá va a ser la conservatoria con la primaria custodia.
And that they will be joint managing conservators.
Y están de acuerdo que van a ser conservadores de gestión junta.
Visitation will be as agreed by the parties when dad is in town with a 48-hour notice.
Visitaciones van a ser de acuerdo a cuando esté papá en la ciudad con una noticia de 48 horas antes.
There is a lifetime child support on this case because the parties agree that the children are legally disabled and will not be able to support themselves.
Hay una manutención infantil de por vida.
And
hold on, and Ms. Castaneda, please place on the record that it's because they agree that the children are disabled and that they are unable to support themselves during their lifetime.
Y es porque es de un acuerdo que el menor está discapacitado y no se puede mantener por sí solo.
The two of them.
Los dos niños.
Child support will be set at $879 each month with a step down of $703.
La manutención va a ser de $879 por mes con un rebaje después de a $703.
Child support will begin September 1st, 2021.
La manutención va a comenzar el día 1 de septiembre del 2021.
No retroactive child support arrears is due.
No se está pidiendo la manutención retroactiva.
Dad to reimburse the state $113 for Medicaid, and the parties to split 50-50 of uncovered costs.
Papá va a regresar para el estado 113 y los demás costos médicos se van a repartir 50%, 50%.
Medical support reimbursement to begin December 1st, 2020.
La atención médica va a comenzar, I'm sorry, Ms. Love, did you say December 1st?
December 1st of 2020.
Okay, la manutención médica va a comenzar el diciembre 1 del 2021.
Mom is awarded 100% of 1202 Miracle Lane and Mission furniture, fixtures, and items therein.
La mamá se va a quedar con 100% de la propiedad en 2002 Miracle Lane, Mission, Texas, con los contenidos de adentro.
And dad to sign gift deed to mom on or before the decree is signed by the court.
Y papá va a firmar la escritura de la donación antes de que se firme el divorcio, el decreto.
Dad to be awarded 100% of his return.
Papá se va a quedar con 100% de su jubilación.
Each keep their own vehicles in their possession.
Cada quien se va a quedar con sus propios vehículos que tienen en su posesión.
Life insurance policies, personal effects, and bank accounts, each keeps their own in their respective names.
Okay. Seguros de vida, cuentas de banco se van a quedar con cada quien que tengan en su nombre.
Each keeps their own debt and debt associated with property awarded to each party.
Cada quien se va a quedar con su propia deuda que se le asigne a papá o a mamá.
Respondent is requesting a name change to Mereda Anzaldúa.
Ms. Cerda está pidiendo, ¿qué se le pidió a Anzaldúa?
And just a correction on the final decree, her name is spelled Mireida.
Can you give that to me again, Ms. Love?
Mireida. We're just replacing the Y for now.
Okay. Y para corregir el nombre de va a ser M-I-R-I-Y.
No, I.
M-I-D-A.
Do the parties understand the agreement here therein?
Mr. y Mrs. Cerda han entendido las partes que se hicieron hoy.
Sí.
Yes.
Yo quería hacer una cosa, o sea, yo no me fui en el 2016, yo me fui en el 2018.
Okay. Mr. Cerda, I didn't leave in 2016, I left in 2018.
Okay, we can go ahead and put 2018 for the purposes of this decree. On or about 2018, that's fine, because it's not going to affect anything.
Okay, podemos poner eso podemos hacer esa corrección.
The parties are asking the court for a divorce at this time?
Okay. Los dos están pidiendo a esta corte un divorcio.
Sí. Así es, correcto.
Yes,
and it's because of discord or conflict in the marriage.
por discordias o conflictos en el matrimonio.
Así es.
That's correct?
And
Sí, es correcto.
they are not expecting any other children from this marriage? Nobody's pregnant or they're not planning to adopt?
En este tiempo no están esperando a niños y no tienen planes en adoptar.
No.
No.
And they've lived in the state of Texas and the county of Hidalgo for at least 90 days. The state of Texas for 6 months, county of Hidalgo for 90 days.
Y han sido domiciliarios del estado de Texas por el último periodo de 6 meses y del condado de Hidalgo por los últimos 90 días.
Okay.
Yes, yes.
They are telling the court that this is the best interests of the adult disabled children? Yes.
Y ustedes le están diciendo a la corte que este es en el mejor interés para los niños que están deshabilitados.
Sí.
Yes, yes.
And they believe that this is a just and right division of the estate.
Y ustedes creen que esta es una justa y correcta división del estado.
Sí.
Yes.
And they are asking the court for a divorce at this time.
Y le están pidiendo a esta corte ahorita un divorcio.
Sí.
Yes.
I did want to clarify, and I don't know if I put it on the record, but moms to determine residence of children without geographical restriction. Dad doesn't live in this area.
Y también mamá va a determinar la residencia de los niños sin condiciones. Is it to Hidalgo County?
No, without geographical restriction because dad doesn't live in Hidalgo County. He doesn't.
Sin registraciones para vivir en el condado de Hidalgo.
However, visitation will stay the same.
Pero visitaciones van a mantenerse igual.
Okay.
And Judge, just for the record, Judge, my client basically works out of the state for the most part. And so whenever he's in town, he will give mom 48-hour notice of the visits because we're not able to enter a standard visitation since his employment varies from month to month, Judge. In addition, he has been providing support to give the children. I'm sorry.
I'll need to give your time to translate.
I didn't hear that, Ms. Love.
You'll need to give her time to translate.
A 10 to 10?
No, she's just making an announcement to me.
Oh, okay.
For clarification. Yeah.
Okay. Yeah. So she'll give her the 48-hour notice, Judge, just to explain to the court. In addition, he has been providing support for these children for the most part, Judge. So he does not owe her arrears. There's no arrears at all, no retro child support being asked, Judge. So his next payment is due this month. And also, just for clarification on the step down, Judge, the step down would only occur if one of the children were to become able to support himself, Judge, or deceased, Judge. We don't see any other reasons for the step down.
Okay, just make sure that you all put that very clearly in the divorce decree, or has that been stated in the divorce decree?
Judge, and I'll work on the divorce decree and I'll put that on the divorce decree that the step down will occur only if the disability of the children is lifted or one of the children were to pass.
Okay, and is that your understanding, Ms. Love?
Yes.
Okay.
Your Honor, what I do want to double check is we put September 1st, 2021, because that's when he started giving payments. We just need to verify that it's the exact 879. There wasn't anything owed or due. And I don't know if November was given, so I just didn't get a chance to verify those things. So just to be on the safe side, we put September 1st of 2021, but we didn't go back all the way to 2016.
Okay. As long as you all understand and have that written out correctly in the divorce decree, and I mean, if you all sign off on it, I'm going to assume that, of course, you all read it in our understanding. So the court will approve the agreement as testified to on the record and will grant the name change as requested by Ms. Palacios Love's client, and finds that this is in the best interest of the disabled children, and also that it's a fair and equitable distribution. So as soon as that divorce decree is signed by all of you and submitted, it'll be forwarded to my queue for signature, okay?
Yes, ma'am.
Your Honor, since we did prove it, do you still want everybody else to sign off on the decree or just the attorneys?
I do want for them to also sign off because of the special circumstances of the children and the way that you all are going to have the language with respect to the child support rate.
Okay, perfect.
Okay?
Okay.
Yes, ma'am.
All
Thank you,
right.
Judge. May we
Thank
be
you.
excused?
Yes, you certainly may.
Yeah.
Okay, Ms. Martinez, do you have a quick announcement? Because I do have 2 contested matters.
Your Honor, we're here if the respondent has been served. If he is not here in court, we would request a default on this case.
Okay, that's P0333-21-9, Ashley Mendez versus Christopher Regino. Is Mr. Regino present? Christopher Regino. Christopher Regino. Okay, I have called out the name 3 times and no response. What date did you serve the respondent?
He was served on October 28th, Your Honor, 2021. By substituted service, Rule 106.
So his 20 days has not expired yet. So his answer deadline has not passed.
Okay.
So you can't take the default judgment. However, what I'll do is I'll go ahead and I'll extend the protective order. And I'll extend it until his answer deadline has passed. Let me see, 1, 2, 3. Okay, his answer deadline will be on Monday, November the 22nd.
Monday, November 22nd. Yes, Your Honor.
And I'll have you come back on December the 15th at 9:30.
December the 15th at 9:30?
Yes.
Okay, December the 15th at 9:30. Thank you very much, Your Honor. I appreciate that.
All right, thank you.
May I be excused, Your Honor?
Yes.
Thank you.
Y démelo firme, me tienen que mandar la página de firma para atrás, ¿ok? Pero
Okay, Mr. Cardenas, did you have a quick announcement or are you on these contested matters?
Well, Your Honor, that's actually a good question. It's rare that I don't know the answer to that. We're here on number 15.
Okay, that's CL 174388-I. And I believe our office received a call from Mr. Gibson stating that you'd be making the announcement on both of your behalves.
Okay, well, Your Honor, I can, in a way. This is a case about property damage. After a flood, my client, ServPro, went in and performed some remediation on Mr. Gibson's client's property. Then they, in some way, they weren't happy with it or claimed that we did more damage than what they already had through the flood, and ended up in this lawsuit. This all stems from, and we're here back again, unfortunately, Judge, this was a motion to compel originally. We've given the plaintiffs time to an extension and time to produce documents that they submitted to FEMA as a result of to get reimbursed for the flood damage. Obviously that has a lot of statements about property value and what they lost and all of those things. And then they were paid by FEMA. So we needed those documents on this case, obviously, with all the statements of value and all the alleged value to the property. Since then, they agreed that they would produce it, and there's been orders to produce it. They've failed to produce it. It led to a motion for sanctions where, again, Mr. Gibson agreed that he would produce it. We even asked, can you just give us a signed authorization? We'll go get it. This is since 2019. Now it's in June 2021. We were here in front of Your Honor again, asking for him to produce it because there's been no movement. Still, to this day, there's been no movement, no documents and no authorization. And that's really all we want, Your Honor. I don't even know what to call these motions anymore. If it's a compel, sanctions, and this, and Mr. Gibson always agrees. So that's why I say I don't know if this is agreed or not, Your Honor. It's just he agrees, but then nothing happens. And we're just trying to see what we could do. And I'm all ears if Your Honor has any ideas as to what we could do to maybe prod Mr. Gibson a little bit to get something done.
Okay, well, I really think that what I need to do is make sure that both of you are here present at the same time so I can get either set deadlines or some form of parameter. So what I'm going to do is, let me see. Ms. Rivera, do we have any room on the November 10th docket at 11?
Yes, Judge.
Okay, I'm gonna have both of you come back on November 10th at 11, but Mr. Gibson does have to be present because we do need to talk this out.
Yes,
So if you can please let him know.
We
It's
will.
November 10th at 11, and all counsel on this case that is authorized to make an announcement needs to be here. So Mr. Gibson does.
And this is just the resetting of this present motion.
Yes.
Okay. Very well, Your Honor. Thank you
on.
very much. May I be
Yes.
excused?
Wait.
Will you be
Oh,
requiring?
I'm sorry. I'm sorry.
I'm sorry. Will you be requiring another oversetting hearing just so we can keep an eye out for it? No?
No.
Okay. Just
No,
making
this
sure.
will be a setting off the bench. So it'll be November 10th at 11. And if you can please let Mr. Gibson know that he does have to be present at that time.
Yes, Your Honor. We'll send him, we'll contact his office and contact him and send him written notification as well.
Okay.
Thank you, Judge. May I be
All
excused?
right. Yes, thank you. Okay, who is on the phone? If you can please announce yourself with the ending digits of 043, unless it's one of you all that are pending on your summary judgment motions that for some reason have somebody on the phone. All right. Ms. Miller, did you have another case? I thought you had announced that you had already finished your cases. Oh, she doesn't have her audio connected. All right. Okay, then we're gonna start with the contested matters. And let me go back and let me recall CL 17-2740-I Rosa Jaramillo Sandy versus Fermin Arce. Mr. Reyes and Mr. Guerra.
Good morning, Your Honor. Samuel Reyes for Rosa Jaramillo Sandate. Judge, this is our motion for summary judgment and we're ready to proceed, Your Honor.
Okay, go ahead.
Your Honor, I asked the court take judicial notice of our motion that was filed on September the 23rd, along with all the exhibits that were attached to that motion, Your Honor, as well as medical and billing records with authenticating affidavit that was filed with the court March 12th of 2019. And we're asking for all those exhibits to be admitted into evidence.
Mr. Guerra, any objection?
No objection, Your Honor.
Okay, then they'll be admitted.
Your Honor, as a matter of law, plaintiffs are entitled to judgment on liability against the defendant based on the proven and established facts. There are no genuine issues of material fact. Texas Rule Civil Procedure 166A provides that a summary judgment may be rendered on the issue of liability alone, although there is a genuine issue as to the amount of damages. So we're not going to get into the amount of damages just to establish that there's no issue as to liability in this case. The facts of this case are that my client was stationary at a red light on the southbound lane of 23rd Street at the intersection of the 4100 block of South 23rd Street and Elmira Avenue, waiting for the light to turn red. They were properly situated and waiting for that red traffic light and to turn green. And then suddenly the defendant, Fermin Arce, collided into them from the rear. Defendant Fermin Arce failed to keep a proper lookout. He failed to control his speed. And this caused for him to collide into my client's vehicle. That collision caused my client, Rosa Jaramillo, damages and injuries as shown by the attached medical and billing records, including records that are from Rio Grande Regional Hospital, which were attached to my motion, and the other authenticated medical and billing records from Kid Chiropractic that were filed on March 12, 2019 that the court has admitted into evidence. Additionally, Your Honor, Exhibit C is the Texas Peace Officers Report, also in evidence, which states that the facts as they occurred, and it states Unit 1 crashed into Unit 2's rear bumper with Unit 1's front bumper, and Unit number 1 failed to control speed. That Texas Peace Officers Report is confirmed by the deposition testimony of Fermin Arce, the defendant. That's also set out in quotes in the motion, and we also attach those excerpts of this deposition. Line 10, page 22, which quoted in plaintiff's motion. Line 10 is discussing the peace officer's report. He's asked, and it says Unit 1 failed to control speed. Factor condition 22. Do you agree with that? Yes. Is there anything you could have done differently to avoid the accident? Yes. Keep my eyes on the road. Is there anything my clients could have done to avoid the accident? No. Okay, so you're accepting that you were at fault for this accident? Yes. So defendant admits to failure to control his speed and failure to keep a proper lookout. On page 23, line 13 of that same deposition, did you collide into them and then you saw them, or you saw them before you collided into them? No, I hadn't seen them. And then once I looked up, I saw it was too late for me to brake, and that's when I hit them. And then further down, did you admit to the police officer?
Mr. Reyes, I'm sorry, but you froze.
I'm sorry, Judge. I guess.
The last thing you said was, did you admit to the police officer?
Yes, Judge. In the deposition, did you admit to the police officer that you'd been distracted with a radio? The defendant responds, yes. Also, interrogatory number 6 from the plaintiff's verified answers to defendant's interrogatories, which is also attached to the motion as Exhibit D. But Fermin Arce did apologize after the accident to plaintiff and admitted to plaintiff that he had been distracted by the radio. He also admits that in line 19 of his deposition that he apologized to plaintiffs. The elements of the cause of action for negligence are a legal duty, a breach of that duty, proximate cause, which includes cause in fact and foreseeability, and then damages caused by that breach of the duty. In this case, the defendant owed the legal duty of care to control his speed and keep a proper lookout, and he admits that he breached that duty. That breach was the proximate cause and cause in fact of plaintiff's damages and injuries. The cause in fact was the Negligence Act, a substantial factor in bringing about the injury. That breach resulted in the rear end collision, which caused my client's damages. That is the but-for causation. It was clear that it was a substantial factor in bringing about those injuries, his negligence. Also, it was foreseeable that the failure to keep a proper lookout and control his speed on the road could cause him to rear-end plaintiffs, which is what happened. We also have, we have all of those elements, the legal duty, which he did have to have a duty of care, to keep a proper lookout, and to also control his speed, which he admits. And the police officer's report all establishes that he had that legal duty, that he breached that duty. And then the final element is actual damages, which we have Exhibit E, which are the Rio Grande Regional medical records, received an MRI, which showed a 2mm disc herniation. We've got the Kid Chiro records that are authenticated and on file since March 12th of 2019. We also have Exhibit H, which shows the damages to the motor vehicle. Those are all damages that were caused by this accident, showing the last element, Your Honor. So as a matter of law here, and the defense has responded, which we replied to them, which that also we asked the court to look at that, but basically responded and said, well, they're still subject to interpretation as far as what the defendant said. But this is really kind of going out into just murky waters. The very clear and plain meaning of what's been established is that there's really no question here as to the facts. The defendant has admitted that he rear-ended, that he wasn't paying attention, he was distracted from the radio. This is in many different areas, including the deposition, the interrogatories, and that my clients had no fault in this. The only other person that could have had any fault was the defendant, which he does admit in his deposition.
Is it just me, or did he freeze again?
He froze again. Hold on.
Sorry, Judge, am I back?
Now you're back.
Okay, so Judge, as a matter of law here, there is no question as to the facts. As a matter of law, the plaintiff is entitled to summary judgment on liability for negligence. That still leaves damages to be proven up, but really because of what the defendant has admitted on his deposition, the Texas Peace Officer report, the deposition, the interrogatories, and the medical records that are all on file with the court and have been admitted into evidence, there is no question, Your Honor, on any genuine issue of fact. They're saying that this open to interpretation is simply just reaching, Your Honor. There's clearly no interpretation as to that he was at fault, he was negligent, and he caused the damages. So Your Honor could essentially expedite this, Judge, grant our summary judgment on liability so that we can go forward then, and now we just have something less to deal with, which is only the damages. So we ask the court to grant our summary judgment only as to liability for negligence. That's all I have at this time, Judge, subject to a response to Mr. Guerra.
May I respond, Your Honor?
Yes, sir.
Just to give you a background on this case, this is a 2017 case. It is quite old. There were two plaintiffs in this case. One we've just recently settled, Your Honor, and we're working on settling the other. Yes, I did file a response to this, what I thought was a partial motion for summary judgment, but it appears that Mr. Reyes is trying to argue a full motion for summary judgment with the medical records and stating that they were caused by this accident. Just because medical records are authenticated, Your Honor, it's still for a jury to decide whether or not they were caused by the accident. That's one. Two, Your Honor, just because that there's a rear end accident and there's case law on that does not mean that there's evidence of negligence as a matter of law. This what he says, partial motion for summary judgment, is taking the province of the jury away. It is a fact question and should be submitted to the jury, Your Honor.
Your Honor, if I may just briefly respond, we are not, my argument is not that because it was a rear end collision that establishes the negligence. My argument is that because it was a rear end collision, that defendant has then given unsworn testimony stating that he was at fault and that he was distracted by the radio, and that my client, the plaintiffs, couldn't have done anything to avoid this accident and had no fault. That is what establishes that that he was at fault and that he was negligent, and that there's no issues with regard to that matter.
Okay. Anything else, Mr. Guerra?
No, Your Honor.
Okay, do each of you have competing orders on file?
Yes, Your Honor.
No, that I can submit an order to that effect.
Okay, because I did notice that you have your motion that you filed on June 5th, but you also have another partial for summary judgment on liability for negligence on September the 23rd.
Yes, Judge, and that would be the one that we're going to be going under, is the one filed on September the 23rd. Okay. That one supersedes the previous one, so the court just has to look at that one. Okay. And then there's a response from the defense, and then there is a reply from us as well.
Okay, so I do see that the response, yes, and the reply are also on file. And what I'll do is I'm going to set a tickler for a decision to be rendered prior to, I'm going to set a tickler for November the 19th. So make sure that you have the orders for me to review submitted before that date. And I would say the sooner the better, because I may render the decision sooner rather than on the 19th. Okay? All right, if nothing else, then you are excused.
Thank you, Your Honor.
Okay, thank you, gentlemen. Y'all have a good day. All right, CL 170066-I, Jesus Martinez et al. Versus Bracewood Management. Announcements, gentlemen?
Good morning, Your Honor. I'm Efrain Molina for Jesus Martinez and El Pastor, Your Honor.
Good morning, Your Honor. John Millen representing the defendant Bracewood Management Series LLC.
Okay, good morning. And Mr. Millen, this is your motion?
Yes, Your Honor. We filed a no evidence motion for summary judgment.
Okay, you may proceed.
Thank you, Your Honor. Your Honor, this case has been around for a long time. It was filed January 5th, 2017, almost 5 years ago. In that time, there's really been very little done from the plaintiff's side to develop the case or to do any discovery. I don't believe, I reviewed my file this morning, I don't believe we received any written discovery. There haven't been depositions taken. And so, certainly this case is one in which an adequate time for discovery has passed for the court to decide a no evidence motion for summary judgment. The case, Your Honor, stems from a disagreement between the parties involving a commercial lease. Long story short, my client purchased this retail strip center that had several spaces that were leased out. And when they purchased it, Mr. Molina's client, Jesus Martinez and El Pastor Grill were one of the tenants in the commercial strip center. There was some disagreement about, when they purchased the property, about the obligations of the parties. But one thing was clear from my client's standpoint is that the plaintiff was in breach of the lease because he was just not paying the rent. Now, at any rate, we're here because we're asking the court to grant summary judgment that there really hasn't been evidence developed of the plaintiff's claim of breach of contract. As the court knows, to assert a breach of contract claim, they have to show that there is a valid contract, that the plaintiff performed under the contract, that the defendant breached the contract, and then there's obviously damages proximately caused by that breach. Your Honor, we filed this because, again, there'd been just so little information developed and it'd been really dormant for so long that we felt like it was appropriate to have the court dispose of it this way. But since we did file it, I noticed that Mr. Molina did file a response. It was timely. But Your Honor, our reply to that response is very simple. We don't feel like the purported evidence provided is competent summary judgment evidence. Mr. Molina provided an affidavit or a sworn statement or unsworn statement, excuse me, from Mr. Martinez, basically stating, talking about the lease, that there's a lease, that apparently his claim is that my client did not make repairs that he thinks should have been made. And he provides, a kind of a list of damages that were purportedly suffered by him because of these repairs that were not made. But all the evidence provided in this documentary form, Your Honor, is not competent summary judgment evidence. Under rule, and we assert it's all hearsay. So we object to the evidence. We'd ask the court strike all the documentary evidence that's been provided and attached to plaintiff's response to the motion for summary judgment. As the court knows, very basically, under the rules of evidence, Rule 803 is the hearsay rule. 803.6 is a rule that says that there are many ways, or 803 says there are many ways that that there are exceptions to the hearsay rule. One of them is 803.6, which is business records, basically records of regularly conducted activity by businesses, and it states in there exactly what has to be pled and provided in order for business records to be adequately proven up and for them not to be hearsay. And that simply wasn't done here. If the court reviews the exhibits attached to the plaintiff's response, Mr. Martinez never says that he's, number one, the custodian of records. He never says that the records are kept in the regular course of business. He never says that it's the regular course of this business for the employer representative of the business with knowledge of these facts to make the record. And finally, he never says that the record was made at or around the time really reasonably soon thereafter of the events that it reflects. And so we feel like, again, very basically, that these records that have been attached as exhibits are not competent summary judgment evidence because they're hearsay. It would have been very simple for Mr. Martinez's statement to make these statements that would bring them within the exception of the hearsay rule. In fact, under Texas Rule of Evidence 902.10, there is a form affidavit that's actually in the rule that sets out what should be said, and this wasn't done. So, we feel like defendants feel like without even having to get into the merits of whether there's a fact issue or what happened, et cetera, because there's a he said, she said about, this alleged damage, the alleged failure to perform the repairs, et cetera. We don't feel like, we feel like there's a defect, in the response, in that there has been no competent summary judgment evidence provided, and therefore plaintiff cannot raise a genuine issue of material fact as to any of the elements of its claim for breach of contract. So based on that, Your Honor, we'd ask that the court grant our no evidence motion for summary judgment and finally dispose of this case that's almost 5 years old. Thank you, Your Honor.
Okay, Mr. Molina, response?
Yes, Your Honor. I have a quick 2-minute presentation. I sent over a YouTube link as well as I filed with the court and gave a copy to Mr. Millen of that presentation. If I could share my screen with the court, I would like to play my presentation. And like I said, it's very short. It's 2 minutes and 30 seconds, Your Honor.
Okay, give me a moment. Okay, it should be on now.
Thank you, Your Honor. Can you see my screen, Your Honor?
Yes, I can.
Good morning, Your Honor. I'm Efrain Molina for Jesus Martinez and Pastor Grill. This is our response to defendant's motion for summary judgment. Defendant's motion for summary judgment should be denied because plaintiff has put forth enough evidence to show the court that there is a fact issue regarding plaintiff's breach of contract claim.
Judge,
Let me give the court a brief background
Okay.
on how we got here.
Can you pause it? I wasn't sure. I didn't know that it was going to be a recording. I thought it was going to be, you maybe looking over some slides, but just for the record, I need for you to put on the record that you understand that whatever's coming out on the presentation of the share screen, that my court reporter will not be transcribing any of that comes out.
Yes, Your Honor, and I'll be more than happy to file with the court a transcript of the video.
Okay, just so you know that this is for presentation purposes only and for me to look at and for Mr. Millen to look at.
That's correct, Your Honor. Not a problem.
Okay, all right, so that is on the record. You may resume.
Defendant's motion for summary judgment should be denied because plaintiff has put forth enough evidence to show the court that there is a fact issue regarding plaintiff's breach of contract claim. Let me give the court a brief background on how we got here. In 2008, Jesus Martinez and El Pastor Grill leased a commercial unit from Retail Endeavors Group. The original lease agreement contained two very important provisions. The first being that the landlord was responsible for the foundation, exterior walls, roof, and other structural components of the unit, evident by the landlord's X in the lease agreement, which was attached as exhibit number 1 to our response. The second provision, section 15H, gave the landlord the duty to make repairs within a reasonable time when notified by a tenant. And in 2019, Retail Endeavors Group sold the property unit subject to its leases to Bracewood in 2019, Bracewood being the defendant in this case. When Bracewood purchased the property, Jesus Martinez and El Pastor gave Bracewood notice of all the repairs the landlord had to make to their unit regarding the roof, the walls that were damaged by a fire, and they gave the landlord notice in the tenant estoppel certificate, which has been attached as exhibit number 4. After being notified about the repairs, Bracewood never made any of the repairs to the plaintiff's units. And when the plaintiff kept complaining, asking Bracewood to repair the unit, Bracewood decided to ultimately evict the plaintiff from the unit. For failing to make the needed repairs to the unit and kicking the plaintiff out of the unit without reason, plaintiffs have filed suit against Bracewood for breaching the lease agreement. In response to the defendant's no evidence summary judgment motion, the plaintiffs have attached sufficient evidence showing that Bracewood breached the agreement when they failed to make the repairs to the unit within a reasonable time in violation of section 15H of the lease agreement. Therefore, a fact issue exists and the defendant's motion for summary judgment should be denied.
Yes, Your Honor. So put like simply, we've submitted the lease agreement, we've submitted the affidavits, and there is fact issues regarding whether or not the landlord breached the agreement when they were notified that the lease unit had damage to it and then failed to repair it and then kick them out. In regards to the defendant's objections, none of those objections are written objections. Usually you got to make written objections to a plaintiff's summary judgment evidence, and on file with the court, there are no written objections, Your Honor. So we believe we put forth enough evidence of each element of breach of contract, and therefore summary judgment should be denied. Additionally, Your Honor, there was an order by this court to have the parties mediate, and that has not been done yet, Your Honor. So basically what we're asking is that the summary judgment be denied and have us go to mediation, Your Honor.
Okay, Mr. Millen, any response?
Your Honor, yeah, one thing, and I know, and I'm glad that Mr. Molina stipulated that the presentation, the recording was not evidence, because it's not appropriate for a summary judgment hearing for the court to receive evidence. But there's one incorrect statement in there, and that is that the transaction where my clients bought the real estate was in 2019. It was actually in 2016. And of course, this case started in 2017, so I don't see how the case would have predated that transaction. And I disagree with Mr. Molina's assertion that there has to be written objections on file. The court is the ultimate arbiter of what evidence is admitted. And the court on its own can decide whether the evidence is competent summary judgment evidence. Having said that, we have objected on the record. Our objections are very clear and very simple, that these documents are hearsay, and therefore the court can't consider whether frankly, the court on its own without objections could determine that the evidence is not competent summary judgment evidence. So we again assert that it's not competent. Therefore, there's no evidence that's raised a fact issue as to each of plaintiff's claims for breach of contract, and we'd ask the court to dismiss the case. We did, Your Honor, the court did order us to mediation several months ago. At the time, we did have an objection to that because we felt like until we got the court's either decision or guidance on a motion like this, on a dispositive motion, it would not be meaningful for my client to try to mediate it. I understand, and of course, if the court orders us to mediation, we will be there in good faith, and we will do our best to do so. But at the time that the court did so, this case had been dormant just for so long, and there'd been so little done by the plaintiffs to develop the case and providing any discovery or any information that we felt like we really needed, a decision on a summary judgment or dispositive type motion before that could even happen. So having said that, I don't think we get to that point because as we pointed out, plaintiff has not created a genuine issue of material fact as to each one of its elements of its claim. And so we'd ask that the court grant defendants no evidence motion for summary judgment.
Okay, Mr. Molina, any final words?
Just, we believe everything he said creates fact issues, Your Honor. That's it.
Okay, so do you all have your competing orders on file?
I don't, Your Honor, but I'll file one.
Okay, and Mr. Mullen, are you asking me to look at the one that you filed on September 20th?
Yes, Your Honor, I believe that's the one.
Okay, all right, Mr. Molina, go ahead and get your order on file. I'll set a tickler to make a decision by November the 19th.
Okay, thank you, Your Honor.
Okay, thank you, gentlemen. Y'all have a good day.
Thank you, Your Honor. May be excused.
Yes, sir.
Thank you.
All right, thank you. Okay, I still do not have a response as to who this is on the phone. If you can hear me, please call yourself out. All right, so number one on the court's docket, did anybody call in?
No, Judge.
Okay, so then, and let's set that for the drop docket.
It is set, Judge, for
It
the
is?
drop docket.
Okay.
Yes, they did receive notice.
Thank you. Number three?
Judge, on number three, there was a Rule 11. I did advise counsel that they needed to be file an order resetting. However, it hasn't been filed. But I do know that the respondent's counsel was on maternity leave.
Okay. Just follow up. I know that but it's really Mr. Jimenez that has to file that order resetting hearing as the petitioner. So let him know if he can please get that filed by Friday.
Yes, ma'am.
All right, and then number five?
Number five, Judge, there was a Rule 11, and there was no order resetting. This is an issue we've had prior with this particular case.
Okay, if they don't file an order resetting also by Friday, let them both know. If not, set them on the drop docket.
Yes, ma'am.
Okay, number 11?
Number 11, Judge, I did see a call from Ms. Diaz, but I did not receive it, and I'm trying to trace back who it was received or who took that call, but I don't have anything on file, Judge. I know that she did try to make contact with the court. I'm not sure if you'd like for me to reach out to her since she did attempt to make a phone call to us, but we were in docket when that happened, so I'm not sure if anybody.
Okay, find out if she's gonna need a reset on that matter, if it was worked out.
Yes, ma'am.
Okay, number 12 came in, okay, and on number 13, they still haven't filed the order resetting hearing?
That's correct, Judge. I checked this morning prior to docket.
Okay, let them know to get that submitted by Friday.
Yes, ma'am.
Okay, that's all I have. That concludes this morning's docket.